My name is Leah Wing, and I'm the co-director of the National Center for Technology and Dispute Resolution. And it is my great pleasure to welcome panelists who are located in the lower 48 in the United States, and also webinar attendees as far away as Argentina and China and Canada and Missouri. And so we thank you all for being here. And I would like to make a couple announcements before we get started. One is that if you have students or others that you want to encourage to watch this, the webinar will be hosted in the video archive in the National Center website, which is odr.info. And also would like to welcome everyone to please attend the upcoming online dispute resolution forum. The ODR forum is usually in person every year, as ironic as that sounds, but this year it will be virtual, and it will be March 1st and 2nd. The first day focused predominantly on AI and ODR, and the second day focused predominantly on dispute system design and ODR, with many other rich topics to be presented on as well related to ODR. And it will also be a day to celebrate the new edition of the treatise in the field on ODR called ODR Theory and Practice. We're very excited that that's about to be launched, and we hope to see all of you on March 1st and 2nd. You can find out more information at odr.info on that as well. So without further ado, thank you everyone for being here. We are going to have a conversation today on online dispute resolution and the courts, and I'm about to turn it over to our distinguished fellow, a member of the fellows at the National Center, Paul Embley. But first, let me introduce Justice Deno Himonas from the Utah Supreme Court. He was appointed to the Supreme Court in Utah in 2015. And for the decade prior, he served as a trial court judge in a court of general jurisdiction. He is deeply involved in access to justice movements, and often can be found speaking about that issue around the country. He's also a leader in the incorporation of ODR in innovative ways to the court system, which we're going to hear about today. And he's going to be in conversation with our own Paul Embley, who's the CIO of the National Center for State Courts. He's the technology division director there, and he has led justice-related IT assessments and technology initiatives ranging from child welfare and terrorist watch lists to online dispute resolution. He's currently involved in international, national, and localized technology initiatives for criminal and civil justice with a special emphasis on ODR. And he has been working with courts all over the country as well as advising abroad. So without further ado, I turn you over to Paul, and I'm very excited to hear about this conversation. Thank you.
Thank you, Leah. It is so great, and I love sharing the podium, or even if it's a virtual podium, with Justice Himonas. We enjoy each other's company. Hopefully, we make each other stretch, you know, in our conversations, and we want to certainly encourage you to be engaged as well. We don't have, you know, as you can imagine, if we had 60 of people unmuted, that it may get a little chaotic. So we do have the chat. I am monitoring that, and we want you to engage as we have this conversation. So with that, let's start out, Justice Himonas. Maybe you can tell us what the current state is of ODR in Utah.
We are in the process of making ODR the way in which all small claims cases are handled. We flipped the switch on 2 more courts on February 1st. So soon, you know, within, I'm imagining, the next 6 months, every court across the state that handles small claims will be online. Building a new set of rules, entirely new set of civil rules that will govern those. Those would be based largely on the rules that we have in place for the pilot. But we're rocking and rolling. At the same time we're doing that, we're trying to really upgrade the software based on feedback we received from a really, really terrific USX analysis conducted by Stacy Butler and her team out of the Innovation for Justice Lab at the the University of Arizona.
So let's go ahead and talk a little bit about that. Obviously, you received a little bit of negative press, but hopefully you're receiving a lot of kudos. I know a paper is soon to be released on that study yet again. So tell us, why is that study significant in ODR?
So, look, I think that the programmers always think that they have built the greatest thing ever. There's nothing wrong with it. How could you possibly improve on it, right? Yet this multi-billion-dollar business exists that has proven that theory wrong over and over and over again. So to my mind, this is, look, I think that the courts need to treat the people that approach the courts as customers, and provide them with as positive an experience as possible, efficient experience. And you can't, we just don't have the ability to kind of read our own code and do that internally. You need to turn outside to the pros. And the feedback we got was terrific, right? Yeah, I mean, there needs fixing. As I've said, and been recorded of saying, I would have been disappointed if the report came back as, oh, nothing wrong here, because it just means they didn't dig deep enough. Well, plenty wrong, plenty needs fixing. But if you don't engage with the USX community, you don't get that kind of feedback.
So maybe you can give us an idea of a couple of the things that they found and how that's impacting the way that you're looking at the process in small claims.
So let me give you three. One, interestingly, was not a technical fix. One is identifying that the information provided in the traditional summons was really clunky, and recommending a QR code. Yeah, it's brilliant. I mean, we ought to be doing that not just for ODR cases, but across the board. So we'll have a form with a QR code that'll get people right into the website. That there were just specific issues that they targeted. For example, the ability, unfortunately, we thought we had guarded against it, to unload stuff you didn't want uploaded. So lots of technical spotting, some big picture stuff, and then also kind of highlighting for us that we really needed to improve the ADA aspect of our program.
Great, thank you. So let's go back to the rollout. So you're getting close to having all of Utah rolled out, and I know that there are concerns about access, whether that's technology, people having technology, or whether that's access as in disabilities. Maybe you can talk a little bit about what is it that you're seeing as you have this, shift to mandatory online dispute resolution?
Oh, yeah. I think the most powerful point from our pilot has been that both sides want to engage with ODR, that do get involved. People could opt out if they don't have the technology, if they have language barriers, if there are other issues, really simply, just really, really simply. Yet, overwhelmingly, nobody wants to opt out. There are a few, but they're really just, it's, as you know from the data, utterly de minimis. And it's not because we've been turning them down. I mean, at last I heard, we turned one down who indicated that he didn't have the ability to access the internet in his email, so you need to make a little bit better showing than that, but that's it, right? And that's a really powerful, I think that for us, that's really, really powerful that the people that are engaging with the system want to use the system and not get out of the system. So lots of room for improvement, no doubt, but we think that's a pretty good indicator that folks like what they're seeing.
And I love that story from Judge McCullough, from one of the courts where he says, I give anybody who asks for an exception, an opt-out, I give it to them except for this one individual who said he didn't have technology, but he was emailing me back and forth. And, as soon as I'd email him, he'd email me back. So he knew that he definitely had access to the technology. So
Well, I think there are two questions on that are posted that relate directly to this. And one is how we define ODR, if it's video conference only or chat based. And I would say it's both. So the ODR system, the platform that we have built is chat based, but ODR, the broader definition, right? I want to see a lot more video presentations happen. We have the ability to do that within these cases, just using these third-party platforms. We use WebEx in the state courts, so the partial explanation, really excuse for my technological incapacity, but it's not just chat-based. It has the ability I mean, again, in my sense, and I don't know about yours, Paul, but really any of these other platforms. And the pandemic has just illustrated our ability to move really quickly and to adopt video platforms for presentations of evidence.
Right. And while the Utah platform doesn't have the video built in, we know that there are other vendors who do have that built into their system. And I know Justice Himonas, you and I and your team there in Utah have talked about, do we go to video, and when is the appropriate time? There's as with any successful technology implementation, you have a list longer than you have resources to make all these changes and all these updates, and so it's exciting to see the progress that you've made. So one thing that I did want to mention is that when we looked at the numbers, NCSC looked at the numbers, we were seeing less than 2% of the people, opting out. And as we've said before, they are pretty much all granted that opportunity. Now, Justice Himonas, one of the things that is being asked is, how do you handle people who don't speak English as their first language?
So it's a great question, first of all, because, before we launched the platform, we were really concerned about this and what we were going to do about it. And this is one of those lessons about what you learn in the process. Turns out that it's not been a concern so far at all. So we were prepared to, set up whether it be Google Translate or some other sources, provide, some translators. But so far, because it's done asynchronously, so those non-English speakers have the ability offline to engage with family members or others, and it just kind of work through the communications that way. The engagement, at least to us, appears to be higher, right? They're not seeking to get out of it because of those barriers, right? They don't have the pressure of being in court. They can deal with it on their own time. And it's been a really, a pleasant surprise. I see there are a couple more. Paul, I don't know if you have the USX study, but I do think we should post that.
Yep, I'm getting that right now. And, Justice Himonas, one of the things that I wanted to mention that I observed was that I actually went and observed your court, and these are people who started with the ODR process and then, could not come to a resolution and so ended up in court. And what was interesting to me is that, there were 3 cases, which is not typical. Before ODR, it was at least 50 to 80 cases, but this day there were 3 cases. 2 of them were people who did not speak English as their primary language, but in every single instance, they came to the court better prepared because they had been working through the issue online. They didn't come to a resolution, but they did have, they had refined what the issue was, and they came to court prepared with the appropriate documents and the appropriate, arguments, so to speak, for what their case would be.
So a couple of really good follow-ups. Are we going to charge litigants? No. I mean, there's whatever the cost is before, there's no additional cost for using the platform. That was really a large consideration on why we built in-house. Are there times that a neutral is brought in? Absolutely. In fact, we call their neutrals are facilitators, and they're there to help parties negotiate the system. They're there to offer light procedural advice and are authorized to do so, something that is also pretty novel. And they're there to help resolve the dispute. So I see the follow-up on the non-English speakers. Right, you don't know. I mean, that's, you can't assure yourself that the person on the other end, right, is that the person who's translating for the person on the other end is doing so correctly. That's an acknowledged flaw that we have, so there's still room for kind of another source of information or interpretation. Just don't see it as being as crucial as it was up front. And I will note, you say that you have a large percentage of the population being non-English speaking. The primary jurisdiction we rolled this out in has a really high ESL population, and we picked that jurisdiction in part because of it. So I can't give you the percentage for that particular jurisdiction off the top, but I think I can say it's significant in that zip code.
So Justice Himonas, I just posted the link to both the usability study as well as the NCSC study. So maybe you could talk a little bit about the NCSC study. And I know that you and I were both disappointed in one area of the outcomes, but obviously some opportunity for improvement there. So maybe you can talk about some of the highlights and
sure. So the highlights are that, I mean, if you look at the study from the National Center, from the court's perspective, it's a home run in terms of efficiencies, right? Great. The big disappointment that Paul's referring to is not really demonstrably reducing the default rate. And I chalk that up to a couple of reasons. One, some of the USX issues, maybe I'm not, the study is more suggestive of that than I am. I think it's really an education and marketing issue. But I also want to say I'm disappointed because we tagged that initially as a metric, but I'm not sure in these cases that's a very good metric. The problem that we were discovering in these cases is they're primarily debt collection cases. And in these debt collection cases, if you do engage and respond, your damages go up. The amount that can be recovered against you for fees and costs and what have you, right? So people and we're hearing from lawyers, like, they like to volunteer, they like to help, but what they find in these debt collection cases is they've just increased the cost for the people by doing that, because now they're responsible for the attorney's fees and things. So it's a tough balance. We want people as involved as much as possible, but I also don't want a system that just unnecessarily runs up costs for folks because it's too easy. I think this is largely driven by the overwhelming number of debt collection cases that are going to have a pretty high default rate no matter what. What I'd like to be able to do is, and we're working on it. Like, interestingly, again, it's with Stacy Butler from the University of Arizona. She's running a large medical debt project that she's studying in Utah, and how we might help those folks without running up, just managing to run up their costs. So pre-litigation engagement and information.
Yeah, and I think that's a great case type to pursue. I know that Tennessee actually is taking on medical debt as their first statewide ODR program, and they'll be launching here in a couple of weeks. And to me, that's really exciting as we look at both the landlord-tenant evictions, as a result of the pandemic, and then the medical debt. Now, as somebody pointed out to me, one of the problems that you have with medical debt is that people exhaust their credit cards first. And so then you have this consumer debt on top of the medical debt, and how do you sort through that? But the nice thing is we have brilliant minds that work on that.
Yeah, it's really interesting. This work that's being done by out of the Innovation for Justice Lab, that they've targeted 3 different approaches. One, for example, is working with the College of Social Work and trying to empower social workers, people that get their bachelor's in social work, to be able to help and provide some legal advice and help in these areas. So
yeah,
I mean, it's a tough. There's not one solution. It's a tough nut to crack. I don't know what to say other than that.
Yeah, no, you're absolutely right. But the nice thing is that these tools give us an opportunity to dig into that. And going back to the NCSC study, one of the things that I know, whenever you do a study, you end up with more questions. And one of the questions that I know you and I have talked a little bit about is the fact that, people start the process and then drop out. Well, we don't really have a mechanism for measuring why it is that they dropped out. Did they start the process and go, oh, wow, I owe the debt, and so they went and they paid it? I mean, that would be a good outcome, right? Or they dropped out because they couldn't use the technology. Well, that's not a good problem. And so, one of those things is, at some point we'll be able to get in and measure that kind of thing as well.
Yeah. I mean, anecdotally, it doesn't appear to be the technology. And I don't think it's coming in and saying, oh, I owe the debt, I'm going to pay it. Unfortunately, in these debt collection cases, that is just largely not the way that works. If they were going to pay it, they stay in the system, they structure the payments. But again, this is anecdotal because you're right, it's not been studied, but it appears to be right. I think it's a plus, and it's a plus in that they've come into the system, they've engaged with the system, and they have figured out, I've got a legitimate problem in debt here and legal claim. And rather than continue to just participate, they're making an economic decision that says, my time is valuable. I'm going to owe this money. I'm not going to be able to pay it. I'm going to, now with the additional information I have, is kind of disassociate. So, that is not, that's not necessarily, it's kind of an informed decision in some of these cases.
Yeah, absolutely. And really one of the things that we continually talk about with the concept of legal portals is getting people the information that they need. And so if somebody engages, while we'd rather not have them engage in ODR and find that out, it's still, if they're engaging in ODR and figuring that out, then, in some ways the court helped. Now it would have been better if they would have stuck with it, but yeah. I'm just going to push
back against that. I'm not sure. It depends on the case type, right? Yeah. I mean, it may not be the case. It may be the economically most wise decision to not. If it's like, I can't afford it under any circumstances, I'm now convinced I owe the debt.
Yep.
Yeah, I don't.
But the one thing, that I hang on to was when we were analyzing some of the chats and how the people were using those opportunities to do out of the box thinking in terms of their debt restructuring. Where, hey, grandma gives me a birthday gift every, May, and I know that I can apply some of that. And so what we were seeing was some of, not seeing the, oh, you pay $200 a month kind of thing. We were saying, okay, in May, you pay $500, and in, July, when you get your bonus, you pay another. And so it was interesting to me. Well, one of the questions that was asked was what percentage of Utah is non-English speakers? Would you happen to know that?
I don't, but I do. The National Center study, Paul, if I recall correctly, has some data that's built into it on in the pilot areas, particularly the West Valley area, in that zip code, the non-English speaking population. So it might be nice if you haven't posted that already to post that as well.
I did.
Yeah, but Utah has a pretty high percentage of non-English speaking population. We have a terrific Hispanic population, and
Yep.
some a lot of other cultures as well. But
and a great Greek one as well, right?
Right. That's right. People may not know that, but one of the original stopping places when the Greeks and the Italians were emigrating, and Slavs and others were emigrating in mass in the very early 1900s because of the coal mines and copper mines.
Yep. And that is a bit of Justice Himonas' background. And if you want to get him really engaged in conversation, start talking about Greece. So it's great. So tell us a little bit more about this, the role of the facilitator, and how is that different from a mediator?
Yeah, so the primary difference is that they're helping the people navigate the system. Again, it turns out that, and this is why I say that the navigability is pretty simple based on interviews with the facilitators and others. Really, people that they're engaged with aren't needing a lot of help that way. Second is this empowering them to provide light procedural advice, right? We know clerks at the counter could easily answer a lot of these light procedural questions, but they're not allowed to. So we have empowered them to do so, the facilitators to do so for all sides. And frankly, this is an area we need to do better in terms of helping educate the facilitators and working that way, because it's still it butts up against their traditional, mediation concept that I shouldn't. But we've made a decision that it's better off to offer people some, again, light procedural advice that's not going too far in terms of, informing the public versus putting some kind of thumb on the scale.
Great.
So, yeah.
So do you want me to describe your process a little bit? And then
that's funny. We're reading each other's mind, Paul. I was going to say the same thing. You should.
Okay. All right. So the filing occurs and the party is notified that they need to come to this ODR platform to try to resolve their dispute. And as Justice Himonas said, they're going to now include a QR code that gets people right to it. They have, the two parties have approximately 48 hours on this platform, and it's really more or less chat where you can upload documents and things of that nature to be able to work through and try to come to a resolution. It's not exactly at the 48th hour, but somewhere in between, 12 and 48 hours, a facilitator will join into the conversation and say, hey, how can I help you? What, and they basically start that, and I'm going to put it in air quotes, the mediation process. And that goes along for up to 2 weeks. And one of the things that we know from British Columbia is that if it goes beyond 2 weeks, people really aren't going to come to a resolution. And so that has been occurring now. Now, at the beginning of this process, so when the filing occurs, there is a court date that is actually set. And there's a bit of irony because it used to be that court date was set, pretty far out into the future, like 8 weeks. Well, with ODR, they've been able to actually move that up to the point where some people are saying, whoa, that's too quick, let me have a little bit more time. But if they're able to resolve online, then great. And then that resolution is entered into the system and everybody goes home happy. If not, then they keep that original trial date and bring whatever it is that they were using from the ODR process in. Now, the judge does not see the conversation that went on. They have to agree on what parts of the conversation would be brought to court, if any of it, or otherwise they just come and plead their case as though they did not succeed in mediation and so forth. So Justice Himonas, what fine points did I miss on that?
Well, I no fine points. Let me put some blunt points on it. As a result of this process, those hearings where, before I became a district court judge, as a lawyer, I would volunteer my time pro tem and handle some of these calendars. And back then, as now, you'd have these enormous cattle calls where you would have 50 cases set on your calendar. You knew there were going to be a bunch of defaults. You had no ideas which ones were going to default. You couldn't prepare for the cases. They're just because of volume in that fact. And you spent a whole ton of time just working through all that. Now, as Paul said, instead of 50 being set, you end up with 4 being set. Those are informed. They've gone through the process. They know what the issues are. The judge has the opportunity to participate. They get more time. So super happy about that. The second is in terms of the timing. One of the reasons we really tamp down on the time is the data that suggests that often the time that it takes to resolve a case is more important than the ultimate outcome, or as important, right? So sometimes if it's going to take, I think 6 weeks was what we were considering was too long, where it's just not worth it. Right? A couple $100, not worth it. Right. So that was part of it. And it is a great problem for a court system to have when people come back and say, could you slow down a little bit? You're being too efficient in giving us a hearing.
Yeah, don't we wish we had that in all case types?
Yeah, exactly. So I'll take that problem day in, day out.
Yeah.
There's a question about whether the judge has to approve the resolution. Ultimately, so the facilitator will send off the resolution, and the judge ultimately has to sign off on the resolution, right? So for the case, if there's a settlement agreement, the parties can just settle it. The judge doesn't have that particular right. I mean, they can settle it without having a judgment entered, but I'm talking about those cases in where a judgment is being entered as a result. But even before that, there's facilitator involvement, and part again of what we're learning from the interviews with the facilitators is that's when they might say, John, I don't think you can actually afford this. So you need to think about it. So there is that kind of human level check taking place.
Yeah. So Justice Himonas, there actually were a couple questions that were asked in a different method. So how many mediators do you have?
So no mediators. These are facilitators.
Sorry, how many facilitators?
Yeah, absolutely. So there are, I don't know the current answer. We started with a cohort of 6. It's increased now. We've created online training manuals and protocols, increase the cohort as we expand the numbers. We're finding it's a really efficient system, and it's not eating up a huge chunk of facilitator time. These are all, I should note, these are all volunteers. So they're trained, they go through the process, but all volunteers. And, the vision was that a lot of those pro tems like myself and others would move into this space.
Yep, exactly. So great. Somebody asks about, what happens when somebody submits a statement of defense, is that stopped during the negotiation facilitation?
Yeah, it's just not, it's not part of it. You could submit one, but you're having the conversation and then with the facilitator, and then at the end, you can submit a statement from the parties. The parties would have to agree to that, that outlines for the judge what the issues are, what the claims are, defenses are, what remains, right? You can upload evidence to send that way. You could agree to have participate by video if you want. So these barriers and externalities, we've tried to remove as many as possible.
Great. Somebody asked earlier about fees, and maybe you can give us an idea. I mean, there is a fee, but it's not an extra fee to participate in ODR, and there's no intent, if I understand correctly, to impose that.
No, as I said, we early on when we decided to do this, we took a hard look. Are we going to build this in-house, or are we going to go outside to another shop? There's certainly a lot of advantages to both and disadvantages, but ultimately, our first principle in doing this is improve access to justice. And as a court system, couldn't justify the additional per case cost if we went outside. So, I am blessed that we have an incredible IT team, really talented folks in-house that we've built a lot of our products as a result. And this was a winner. It's won design awards, and I'm really, really proud of our people for what they've done here.
Yeah, you do have a really great team. So let's shift a little bit. So what case types do you see next for ODR in Utah?
So I don't know if Stacy up in Alaska is listening, because she's probably going to start yelling at me. But I think what'll come next are traffic cases. Simple cases like that. Now, it's not been approved. This is kind of, Justice Himonas all by himself with a few other small claims judges or justice court judges, excuse me, talking about it. But I think that's where it moves in the future. And I also see a lot of promise when it comes in landlord-tenant cases. If it comes in some family law cases, expect that we'll move in that direction.
Great. And then what about criminal cases? Do you see a future for ODR being able to help out in that, or is that, just a bridge too far?
It's not for me, right? We built this system so it's robust enough that it can not just work at the justice court level, but at the district court level. And the pandemic has taught us that we can and do need to move online for a lot of the resolutions. And while we'll move back in many ways afterwards, hopefully we've learned that there are some places we should never move back on. And there are a lot of those criminal matters that those are prime examples. Again, enormous calendars where people have to come in, and I handled just thousands of those criminal cases where I'd get on the bench at 8:30 or 9 o'clock in the morning, and I wouldn't finish my morning calendar until 2. Right? Not move, not for anything. And then the afternoon calendar, and other people are sitting in the courtroom, right? They're waiting. They don't know when their case is going to be called. And they could be for super minor things. So they're taking time off of work. They're traveling distances, right, for no real big reason. I don't know what the data the National Center's collected. I think we've all seen some of the preliminary data coming out of New Jersey, some other jurisdictions on the rapid drop-off in failures to appear when we've allowed them to engage remotely, right?
Yes.
I just don't think we need to ruin a bunch of lives by issuing warrants for no-shows, not showing up for the cattle call for this 5-minute hearing, right? Yeah. If there's a way that we can guardrail around that.
Yeah, I know that we're trying to figure out how to actually come up with the real numbers, but as we ask judges, across the nation, anecdotally, all of them are saying we are going from, anywhere from 30 to 50% of people showing up to now we have better than 80% participation in pretty much every single case type when it's held virtually, and I love what Judge Emily Miskell from Texas says. She says, we continually talk about technology. Well, you know what? People have been using technology. It's called a car, and they have breakdowns by the side of the road, and they have all kinds of other issues, and we deal with those. So, we need to stop talking about, the technology, glitches as though they're new to, our lives. They're just in a different form than, people not being able to show up because of, X or Y.
Yeah. Look, and you can still, you want to show up, you still can, right? In person. But if we can make it more convenient for you, right, I mean, again, to paraphrase, Richard Susskind, right? Justice is not a place, it's a thing.
Mm-hmm. Absolutely.
We need to be customer sensitive.
Yep. So true. So I'm getting a message. My internet is unstable, but hopefully, we'll continue on. But let's talk a little bit about AI and your thoughts on that. Does that fit in with ODR? How do you see that coming into play in the courts?
I saw that Orna has posted. I think that's something that I wish we could hear from Orna on. I think it has an enormous role, and I think it has it in two ways. One, upfront in terms of the chats and lessening the load on the facilitators. So we're working with an outside agency. They're reviewing of the transcripts, those types of things, to try to build in those chatbot conversations, depending on words that are being used in the chats, and just kind of reduce the amount of pressure on facilitators. We're fortunate that we have I think a pretty large cohort. It can be done for free, but understanding that they're donating their time, that may not always be the case. Really lessen the load in that regard. The second is, I continue to be blown away by some of the data that shows kind of the disparities when the system recognizes, or you recognize as the actor, the specific racial, gender, age profiles of the participants. And how AI may help in that particular regard. And that's why I was referring to Orna's work earlier. Yeah,
Orna's work is great. And I would strongly encourage people to look at that. I don't have a link that I can post, but Justice Himonas did participate in a focus group on AI in the courts, and I did post that paper there. But I think it really does a good job of describing how the courts can make sure that they're mastering AI, and that AI does not become the master of them. But I know both you and I embrace many of the concepts of AI, and obviously we need to have safeguards. But yeah.
Let me give you an example we're working on right now, which is expungements, right? So there is an application for an entrant into the Utah Sandbox, where using court data, the idea would be that they can identify which individuals in the population maybe, not are, but may be eligible for expungement, and reach out to them, communicate with them, and through AI help them fill out the forms, the process, and file it. Internally, been working on implementing clean slate legislation, which ultimately, right, when if we can get this to work, would allow those individuals then, without a court ever having to touch it, except for kind of the final stamp, would have the program identify those cases, working with the Bureau of Criminal Information, whatever, that are truly expungement available. Do this all online with the help of the AI sector, and get your case dismissed automatically, right? Or not dismissed, excuse me, expunged automatically. Really, kind of hyper-focused on that these days. But that's a good example. I think it's an excellent example of when, frankly, right, the computer is going to do a better job than the judge in kind of advancing that and ferreting out these cases that are and aren't eligible, and just making it done expeditiously. I know there's a lot of pushback to that. A lot of my colleagues, in robes, do not like this notion. And to them, I would just say that there are some places where, we ought to have humans out of the loop. And the prime example, I think, and we during the conference that Paul alluded to, is every time we turn on our computer and allow the software to try to ferret out any malware or anything else going on, guess what? AI, right? So we don't give that a second thought now. But there are cases and case dispositions, I think, that are appropriate for out of the loop. Human on the loop, probably the majority of cases, or in the loop.
Yep.
But
well, and if we truly are committed to access to justice, wouldn't we use all the tools that are available to us? We always need to have safeguards, absolutely, and we need to make sure that we're having those rich conversations of both sides of the argument. But if we are committed to access to justice, we really do need to be something.
It's not one solution. We need every tool that we can get our hands on.
Yeah. So let's talk about one of your favorite topics, or at least hopefully it's still a favorite topic. I know you've been taken to the cleaner a couple of times on this one, but let's talk about regulatory reform. How does that fit into the overall picture, not only of access to justice, but how does that affect ODR?
Oh, okay. I love that. Thanks. I don't mind being taken to the cleaner on this. I will defend this this is one of these issues I said I will break my pick on. I am really proud of what we've done with the sandbox, and I'll just give you some examples of what we're talking about. Right, there's a legal regulatory sandbox, which is some place where innovators can come and say, listen, this is a place I think I can innovate. I think that this is how it might help, and these are the rules that I need relaxed. We launched in August. We were the world's first legal regulatory sandbox. BC launched shortly after that, and there are a number of other jurisdictions that are looking to follow suit now. We have, I think, as of last week, 18 approved entities, and they run from such simple things as allowing a small shop where an individual wanted to allow his longtime paralegal to have an equity interest. Great, right? But a non-lawyer owning any part of a law firm has been taboo for such a long time. We busted that particular mold. Two, something really innovative. I mean, one we just approved, for example, involves social workers again. These are trained domestic violence advocates who'd been licensed as domestic violence advocates, but now authorizing a pilot where they provide legal advice.
Wow.
Right? And filling out forms for protective orders. I mean, for stalking injunctions. So they're not making appearances right now, but that's where they're headed. And I don't know if you just saw the ABA. There was an article today in the ABA that New York is also pursuing, looking at licensing or certificating social workers to provide legal advice. We're doing it. We're doing it in this instance, kind of in a controlled, a controlled setting. We're looking at doing it in through the sandbox again with debt collection. It feeds into ODR in terms of the kind of the side programs that are available. For example, out of the development lab at the BYU Law School, they developed a program to help people in debt collection cases to file their answers beforehand. Well, all right, now we don't need the answers, but how about upgrading that with some AI to provide them procedural advice, substantive advice, in those areas as well, and creating a link on ODR that allows them to do that, right? So I mean, those are, it can interact, and ODR from my perspective, Paul, is really the court's own version of an applicant to the sandbox, right? We kind of use that same model where okay, we'll lift the rules, we'll create a different set of rules for this, and we'll pilot it. And then after we've piloted it and studied it, if the data bears it out, we blow it out.
Nice, very nice. This is so exciting. Just so many great changes are occurring, and Justice Himonas, I for one really appreciate your leadership in this area. Just helping us beat down those barriers, and and making it cool, to actually do some of this stuff. So there is one other
Colin
question.
has been encouraging out-of-state ODR platforms to participate in the sandbox. Colin, so first of all, hello. I'd never thought about that. I don't know. I mean, I encourage everybody to participate in the sandbox would be my short answer to that. I think that that's really interesting.
Yeah.
I mean, think that, the sandbox exists for questions like that, so that we could all think outside the box about some of these things that, like, I wonder why I didn't think about that.
Yeah, and that's what I love about having a group like this, is that we get all kinds of great questions. So
look, I don't have any. Let me be clear about this. I don't have any vested interest in one ODR model over the other.
Right.
The only thing I care about is making sure that the consumer, that the customer, is getting the best product possible.
Yeah.
Right. If it's not this one and it's in Colin, it's something else, God bless.
Yeah, exactly. So somebody asked, how does one get into the sandbox?
Well, currently go to Utah. Paul, tell me if I get this wrong. Utah.sandbox.gov. No, that's not right. I don't remember the Sandbox website, which is changing here with a new website, with a new web address.
It's the Office of Legal Services Innovation. Yeah,
but that's not the website address. But if you go to the website address, it'll take you there. If you just run Utah Courts and Sandbox, there you go. Sandbox.utcourts.gov. Thanks, Paul.
Sure.
Appreciate that.
We did have one other question, and that is going back to the facilitators. Do the confidentiality agreements that mediators get into, do those apply to the facilitators as well?
All confidential.
Yep.
Right. Except that the parties, like before, can agree whether, for example, certain documents that were exchanged during the facilitation process, if they want to upload those, they can do that. They can do it really easily through the program. If they want to, submit kind of trial statements, they can do that. Otherwise, what happens during that process is off limits to the court, period.
Right.
And they're told up front in kind of some standard chats that are released initially about the role of the facilitator and that process.
So last question, and whatever parting words you have, but so you live in a state where you're moving things forward. What do you suggest or recommend to those who are struggling in states that maybe are not as accepting? What kinds of advice would you give to people who are slogging up that hill?
I'm going to steal Jillian Hadfield's thunder here, and I think she quotes Margaret Mead. To be honest with you, that never underestimate the power of a small group of people to, paraphrasing again, to change the world. Indeed, few other things have. These all start with a collaborative effort with the right group at the table, just pushing. Right? And you got to be thick-skinned. You're going to get a lot of pushback, and it would be a lie to say that doesn't wear on you after a while. I mean, there's a lot of negativity, and just hearing it over and over again takes an emotional toll. But you surround yourself with well-meaning people. You just try to do your best. But I think Jillian and Margaret Mead, Dr. Mead, had it right.
Great. Well, thank you, Justice Himonas. It is always so good to see you, and can't wait till we get together again.
Yeah. All right. Thanks, everybody.
Okay.
Politely, persistency pays off. Yes.
So now, folks, apparently I'm the one whose video isn't working, but I do want to say, just in closing, thank you so much to Justice Himonas and to Paul Embley for their commitment to innovation, not just for showing up today, but for the amazing amount of leadership that they're providing about increasing access to justice, about harnessing technology to make that happen, and also being courageous enough to repeatedly welcome that we discover what isn't working so that we can make it work better. And also, as we were preparing a couple minutes before the session started, Paul and I, when we were waiting for Justice to join, were kind of chatting about and marveling at the ability of Justice Himonas to constantly make himself available to do the presentations as well as hear from the public. And I think that that is one of the beauties of a democracy that is working hard to work. So thank you both for your time. Thank you all. Stay safe. Take care.